Namaste. Telugu Prajala Mana Sakshi Sakshi TV. I am Swarna. Welcome to Sakshi TV special immigration show with attorney Prashanthi Reddy from the Law Office of Prashanthi Reddy PLLC. Please note down that Sakshi TV now has 3 immigration shows every week on Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Ms. Prashanthi Reddy, and on Friday 6 p.m. EST with Banu Ilindra. Please tune in, ask for questions. If you have any queries regarding immigration, please feel free to contact us, our attorney, and would like to answer your questions. If you are an immigration attorney and would like to join our show, please email us at usa@sakshi.com or call us at 866-725-7441. Before we begin the show, please note down that the information provided on this show is not legal advice. It's for general information purpose only. Sakshi TV or its agents are not responsible for the use of this information. If you need a specific legal advice, please contact attorney directly. Today, we are going to talk about I-485 H1 EAD immigration updates. We have our attorney Prashanthi Reddy garu with us. Without any further delay, let's start our show by welcoming Prashanthi garu. Namaste Prashanthi garu, welcome to the show.
Hello, thank you.
So we are so glad to have you on our show. So Prashanthi, thank you Prashanthi garu. So please comment on upgrading and downgrading of I-4 140s. What are your thoughts on this? Should it be done?
Yes, thank you for introducing me, and thank you for that first question. It's extremely important to discuss this because, as we all know, the visa bulletin, a lot has been happening with the visa bulletin. It's been a roller coaster ride over the past year or so, and recently there's been rapid forward movement in EB2 and mostly EB3 final action dates last month as well as this month. So July and June, there's been a rapid forward movement of final action dates. And also another thing that has happened is we've received some predictions for the possibilities of visa numbers, what the possibilities are for visa numbers being available in towards the end of the fiscal year. As we all know, in September, the new fiscal year starts in October. So usually what happens is the Department of State will move the numbers forward rapidly if they think that the demand is not going to be met. Because if they don't move it forward, then those visa numbers will be wasted. So usually they wait until the end of the fiscal year to move these visas for, give it a, they wait for the forward movement because they want to see how many requests they get from USCIS for the visa numbers. So we've received some prediction from Charlie Oppenheim. He's the one who at the Department of State is in charge for the visa bulletin every month. The visa bulletin tells us what the priority dates are for the various green card categories. And if you've reached that priority date, then you can actually file your case. So what happens is, what has been happening in the last few years is that there's been 2 dates available every month. There's a dates for filing and a final action date. Usually USCIS will use the final action date and they don't use the dates for filing. Only the consulates abroad are allowed to use the dates for filing. Dates for filing are usually a little bit ahead of the final action dates, and the reason they have that dates for filing is so that USCIS can take in some applications and get applications ready. And by the time the applications are processed, the way they're construing it is that they're hoping that the numbers actually become available. So it's kind of like an artificial availability date that is being set. So, but come September, usually between October and March of every year, the Department of State, the USCIS uses the dates for filing. You can file based on the dates for filing because again, they're allowing you to file the 485 in advance because the visa numbers can only be used once the 485 is filed and it is processed. So at the end, after all the documents are in, and the officer is ready to approve, that's when he requests for a visa number. So for all this to happen, first the 485 needs to be filed, and there's some processing time. So taking that into consideration, they've developed this new dates for filing chart. So as I said, every year between September and March, they usually open up, USCIS opens up the bulletin for dates for filing, which means that people who could not have otherwise filed throughout the rest of the year because you have to follow final action dates, they are able to file now based on dates for filing. As I said, they are a little bit more advanced, quite a bit more advanced than the final action dates. So Charlie Oppenheim has given us an indication that same as last year, this year there's going to be, there's not enough visas have been used up. Therefore, there's going to be rapid opening up of the visa bulletin in the month of September. And there are 290,000 employment-based visa numbers most probably will become available, because the family-based visa numbers are not being used because of COVID-19 and travel bans, etc. And the consulates being closed, processing for family-based cases has really reduced. So that spillover is going to come into the employment-based category. And so the availability of 290,000 visas pretty much means that the dates might jump by as far as 4 years. That's what happened last October, and we're expecting the same thing to happen this October as well. So keeping all that in mind, what we're talking about, long story short, is important, because we're trying to give our viewers advance notice of what's going to happen, number one. And also, since there's still time, 4 months more for October, allow them to keep documents ready or make changes necessary so that they can use the visa numbers to a maximum extent. So again, talking about this upgrading and downgrading of I-140s, this is basically why they're doing it. So traditionally, it is not uncommon for people to toggle between the different employment-based petitions. So there's EB1, which is exceptional ability. There's EB2, which is for advanced degree holders. That means anyone who has a master's or a bachelor's plus 5 years. And there's EB3 for bachelor's degree holders. So EB3 being, and below that, if it's below a bachelor's degree, it comes under EB3 skilled worker, but it's the same priority date right now as EB3. So we're clubbing everything as EB3. So it's not uncommon for people who filed under EB3 to then upgrade to EB2 after a few years, because, you know, they've gained more experience. They most probably have received promotion in their job. So, you know, obviously their position is now higher, and the requirements for their job also will be significantly higher. So it's not uncommon for people over the years to move from a EB3 filing, which only requires a bachelor's degree, to an EB2 filing, which requires a bachelor's but 5 years of experience, so more experience. Similarly, as you know, because of this roller coaster of visa number availability for Indian nationals, in last October, for example, EB3 moved ahead of EB2. So even though it's a lower category, the visa numbers became more available for EB3 than EB2. Because Indian nationals, most have a master's degree, so most apply under EB2, and not that many apply under EB3. So there was more demand for EB2. So therefore people, and then what happened is the numbers moved up rapidly last year. So a lot of people downgraded them. So to upgrade, you need to file a new labor, and then you need to file a new I-140 to upgrade from EB3 to EB2. But to downgrade from EB2 to EB3, you don't really need to file a new labor cert. All you need to do is file a new I-140 and check the appropriate column. You check the EB3 column and say, I want to apply for EB3. See, the logic behind that is you can call, even if you're overqualified, it's fine. You still qualify for EB3. So you don't have to refile anything. It's just that you're asking, the employer can choose which category they want to be in, even if they're overqualified. So it's easy to downgrade from EB2 to EB3 as there's no requirement for a new labor cert to file, because filing a new labor cert involves a lot of additional work and involves testing the job market, and then it involves about 6 to 8 months additional time as well. So I think the need of the hour right now, because we're still seeing that the EB3 dates are moving much more rapidly than EB2, at least the dates for filing, which are, which as I explained, might open up in September. A lot of people are filing now downgrade from EB2 to EB3. So I guess the question is, some people ask me, should we file downgrade? And my answer to that is yes, but don't do it as an amendment. There are two ways of downgrading or upgrading for that matter. You can either ask for a new I-140 approval, or you can ask for the amendment of the existing approved I-140. If you ask for an amendment, then you're losing the previous I-140 and you're getting only one new I-140. But if you file a brand new I-140, which you're allowed to do as per the new filed memo, then what happens is you will have two I-140s now. So you'll have an EB2 I-140 and you'll have an EB3 I-140. So tomorrow, if the dates are never predictable, so sometimes EB2 is ahead, sometimes EB3 might be ahead, depending on the demand and supply. As more and more people downgrade to EB3, then EB2 will become ahead. That's what happens. So it's a good idea to file a downgrade, but only if it's filed as a new petition, not as an amended petition. Filing as a new petition ensures that your previous I-140 remains intact and that you have a new I-140. So no matter what happens with the visa numbers, you can choose which I-140 you want to use for filing your 485. Or if your 485 is pending because you've already filed it, like last October you filed it, you downgraded it to EB3 because those numbers were available as opposed to EB2. And then suddenly final action dates for EB2 now are moving rapidly forward. So that's great, because no matter, even if you file a 485 based on dates for filing, that other column, you can't actually get a green card based on that until your final action date becomes current. That's when you get the green card. Until then, you're just waiting. And the advantage is, of course, that you have a pending 485 and you have advanced parole, which allows you to travel, so you don't need to go get a visa. And you have an EAD card, which allows you to work, so you don't need to maintain your H1 status or L1 or other work visa status, which is sometimes difficult to maintain. So, so downgrading is always good, but always downgrade it as a new case and not as an amended case. Now, there could be problems also with reference to downgrading. And the problems are pretty much that it might get denied. Because the employer, you might qualify, but the employer may not now have the ability to pay. Because when you filed the case in 2012, maybe the tax returns of the employer were good. But now when you file a new I-140, they're going to look at the present day tax returns. So if there's no financial ability presently, then they'll deny that case. So the disadvantage of that is pretty much you lose time and money, but you still have your backup, you still have your I-140 EB2. So you're not really losing anything except, I guess, for the time and money that you're spending. So I think final comment is it's good to file downgrade if you need to, file it in premium processing if you can, but file it as a new case.
So how will filing an I-485 application be beneficial to someone?
So as I was saying, there is a great benefit in filing a 485. So as I was explaining, there's two dates, the final action date and the dates for filing. The final action date in the visa bulletin needs to become current for an applicant to actually become eligible for a green card, right? So the final date is a prediction of where, it's also the filing date is also a prediction of where the final action date will be in a year or so. So they advance it by a year. Usually there's a difference of a year. So as this is just an estimate though, there's a possibility that if the advances in dates result in many 485 filings, the date for filing can also retrogress rather than move forward. Right? This can happen also. So while the 485 is pending, what can happen is that the applicant and derivative family members will at least, even if you're not assured of getting a green card in the next 1 year, be assured of getting employment authorization and travel permission so that you don't have to go to the consulate like now. It's impossible to get a appointment at a consulate for a visa because all the consulates are closed. So that can be avoided if you have advance parole. You don't need a visa. And also the other advantage of filing a 485 is there is something called AC-21. As per the AC-21 Act, if you have been working for an employer for more than 180 days after filing the 485, and if your I-140 is approved, you can actually transfer. It's flexible. You can port to another employer and still maintain your green card as long as the job is similar. So that's a big advantage, an advantage of filing a 485, because if you want to transfer to another employer on a H1, it's a difficult process. It could get denied. It's a process. You have to again apply for a H1. And you have to qualify as per that new employment, that new job. So every time you file something with USCIS, it's a problem. Unlike that, with the transfer of employer while you're still on a 485, it's much easier because it's just a simple form that has to be filled out. And it's very rare that these cases get denied, unless the job is completely different. For example, you are working as a programmer analyst and the new job is a financial analyst job or a teacher's job or something completely different. Then, of course, they will deny it. But then nobody will even apply for such a transfer to such a different job when they don't qualify for that job. So logically speaking, this works really well, applying for a 485.
Okay. So viewers, if you have any questions and would like to reach out Prashanthi Garu directly, her number is 212-354-1010, extension is 107, and her email address is prashanthi@reddysq.com. So, Ms. Prashanthi, my next question is, a non-citizen has a child who is 18. Will the child's age be protected under the Child Status Protection Act if the child turns 21 and the I-485 applications are still pending?
No. So, depends. I won't say no, it depends. Under current USCIS policy, the dates for filing depends on what basis. Remember, I told you there are two charts. So, it depends on what basis you filed your 485. Did you file it based on the dates for filing, like a lot of people did last October? Or did you file it based on a final action date? As I said, the dates for filing is not an actual date. It's just something that allows you to file your 485 in advance before the date becomes available. So in that situation, the dates for filing situation, as per USCIS's current policy, which I think should be changed, but has not yet been changed, but there is talk about changing it. So if you file under the dates for filing, the age does not freeze. So the final action date does not become current. If the final action date for them, suppose you file based on dates for filing, and then before they turn 21, final action date becomes current, then even if they don't immediately get the green card, once the final action date is current, the age freezes. But if that does not happen, then they age out. And they will not be able to adjust or get a green card along with their parents. But there are some exceptions to this. And this is called CSPA, Child Citizenship Protection Act. So what they will do under this act is they will artificially decrease the age of the person. If they're 21, they will minus the time that it took for the immigrant petition, like the I-140 we were talking about, right? The downgrade, upgrade. So they will artificially subtract the time that it took for that I-130 or I-140 application to be approved. And then they'll again look at what the age is. If it is under 21 at that point, then they can still adjust if the final action date becomes current. If it is still over 21, then they're out of luck. So that is, that's the only, I think, exception to that. But also, you can only make use of this. So, for example, say that you're under 21, your final action date becomes current, but you don't actually file for the green card. So you're required to file for it. Otherwise, your age won't be frozen. You're supposed to file within 1 year of that date becoming current. If you don't file and then you age out, you can't then say that, but when the date was current, even though I didn't file, my age was under 21. So one requirement is that as of the dates for filing, you should be under 21, or you should be under 21 by that applying that formula of CSPA, and you should have filed for the adjustment of status within 12 months of your date becoming current.
Okay. So must a non-citizen be in a non-immigrant status in order to be eligible to file I-485? What if they are in violation of their H-1B status since their last entry because their employee terminated them as a result of the COVID-19 economic downturn 120 days ago, but now wishes to hire them back?
So yes, if individuals do need to be in a lawful status as a condition to file a 485. But there is one exception. In this example, you talked about 120 days, and there's a reason why that 120 days is in that example. So if an employer terminated the employee 120 days back, then they have been out of status for 60 days only, because there is a different law, H-1B law, which says that you have a 60 days grace period within which you can either leave the country or change status, So from that, and in addition to that, under 245K, this is another separate rule, a non-citizen can still be eligible to file a 485 as long as they were out of status for less than 180 days. So if a non-citizen failed to maintain status for only 60 days, then obviously they can make use of that 245K rule, because that gives them a 6-month period to be out of status. So they'll be still able to file a I-485, and they will be able to use 245K to be able to, if there's any RFE, to be able to document that. So, that's one trick that a lot of people don't know. So you can use the 60 days grace period, and then as per 245K, they allow you to be out of status for 6 months from the date of your last travel. So if you traveled 10 years ago, then most probably your 6 months will be up. But if you traveled recently and then file out of status, they're only going to look at the 6 months after your last date. So yeah, there is an exception. In general, you would think that, most people would just answer no and say, you have to be in status to file a 485, but there are always exceptions. And I think, this is one of the exceptions to this.
Okay. So what if the final action date on non-citizen prior EB2 I-140 becomes current because, before the final action date on their EB3 becomes current?
So the final action date for EB2, yeah. So as I was saying, you can have 2 I-140s pending at the same time. You can have 2 I-140s approved. So you might have filed your 485 based on the EB3 case, but then, as you're saying, maybe the EB2 final action date becomes current, and EB3, and this is a very real possibility of this happening for all those thousands of applications that were filed in October. Everybody downgraded. Hopefully they filed new petitions, so hopefully their EB2 is intact. But they all downgraded to EB3. Meanwhile, EB2, there's been a rapid movement, and the dates, and you always want to use a final action date rather than dates for filing, because only the final action date can give you an actual green card. So if the EB2 final action date becomes current, then obviously you don't want to be using that EB3 I-140, because that is, you file that only based on dates for filing, and you will never get the green card. It'll take forever, because those are not the actual current dates based on which you can get a green card. So when the visa becomes available for that appropriate preference, you can transfer, it's called transfer of underlying basis. What USCIS will do is that they will use the, if there are two I-140s, they'll use the I-140 that's more favorable, usually, and then they will process your case. But they don't always do this. So you can always write to USCIS to request that the 485 application be transferred, to the EB2 case or the EB3 case, whatever it might be. You can also try calling the USCIS, the 1-800 number, 1-800-375-5283, customer service, and request that the 485 be transferred to the other I-140, because the priority date for that I-140 is more favorable and it's based on final action date. Unfortunately, there's no specific form that can be filled out to do this, and whenever you call or you write to them, they sometimes don't respond, and there's no way of tracking it because there's no fee that is paid. If there's a fee, there's always a way of tracking it because you get a receipt. With these requests, you don't get a receipt because there's no fee. So it becomes difficult to track the request, so you have to keep calling them or keep following up. But yeah, that is the biggest disadvantage, but it definitely can be done and is done, sometimes by USCIS itself and sometimes upon request from the applicant. And there's no need to file a new 485 based on the EB2 filing. You can just interfile, the existing, with the existing 485. You don't have to file a new 485 because you're not supposed to file two 485s anyway. You can only get one green card. So even if you file and put all the fees and file it, you'll have to withdraw one of them. So there's no requirement really to file another one. Some people do file because sometimes they're not getting a response about the interfiling. So they go ahead and file another 485. There's no harm in doing that except for the money and the time spent. And you will get an RFE, a request asking you which 485 you want to keep. So, that might delay the processing of your green card. But other than that, there's no disadvantage in doing it, but there's no need to do it either. Interfilings usually work, but it needs repeated follow-up.
Okay. So should I request premium process on that downgrade of I-140 petition?
There's no harm in requesting premium processing, but USCIS might not accept your request. Actually, it's a very good idea to request premium processing because especially now with the dates moving so quickly, you cannot actually get a green card until the I-140 is approved. So even if they want to approve your 485 and give you the green card because your dates are available, they can't unless the I-140 is processed. And that's taking 6+ months. So it's definitely a good idea to apply in premium processing wherever you can. But what is happening with the downgrade and upgrade cases is that when we're sending out the request for premium processing, they're basically saying that they do not have the original documents with them. They have to get the original documents from perhaps a different service center or a different office, and therefore they cannot honor that premium processing request because that has to happen within 30 days. Otherwise, they have to refund the fee, so they usually send back the request. But oftentimes, people have filed later again after 30 days, and then now that they had time to get it, most probably they would have gotten it, and then they accept the request for premium processing when you file it the second time. Sometimes they send a notice saying that please file your application again after 30 days. And in the meantime, we will get it and then we will honor your request for premium processing. So that we've done that as well. So this is what's happening with premium processing. But of course, if it's not a downgrade, if it's just a new I-140 that you file and you have filed it with the original labor, I think for sure you should request for premium processing, because you don't want that to be delay in getting your green card. So the other thing is that it's important sometimes to file premium processing is because of the CSPA thing that I was talking about. So if that there's a disadvantage of filing premium processing, because, for example, if your I-140 takes a long time, that's advantageous because they'll deduct that amount of time from the child's age, right, to decide the 21. So if it's only taking 30 days, then there's that much time that is deducted. Because, you'll only be able to subtract a lesser amount of time. So that's something to think about and plan. It's such a complex process that everything has to be planned properly, depending on what your situation is.
So viewers, if you have any more questions and would like to reach out Prashanthi Garu directly, number is 212-354-1010, extension is 107, and email address is prashanthi@reddysq.com. So Prashanthi, Ms. Prashanthi, so my next question is, a non-citizen has an approved EB3 I-140 filed by a prior employer. Their employer has filed a labor certification and wants to capture their priority date of prior I-140 after the labor certification gets approved. Can the prior I-140 be used to file an I-485 application?
So, basically the question is that this person has an approved EB3 I-140 filed by an ex-employer. And then their new employer has filed a labor certification and they want to capture the priority date of the prior I-140 after the labor certification gets approved. So absolutely, yes, the prior employer would have to offer the job to the employer on a 485J. And it must be a bona fide offer of employment. And the terms of the underlying labor certification of that under the terms of the labor certification approved. If it is not a bona fide job offer of employment, it would be advisable to go ahead and file a 485 based on the previously approved I-140, rather than try to file it through this new employer who doesn't really have a job for you. So it would be prudent then to wait for the labor certification to get approved and then recapture the old priority date from the current employer, right? So basically, a lot of people during this October, last October, they had I-140s approved from their previous employer, but they just left that previous employer and they joined a new employer because they had better opportunity. And just then suddenly the visa numbers became available last year, because that happened very suddenly without that much notice, like a month's notice. So now they're stuck because they no longer have a job with that previous employer, and they've already started working for the new employer. So yeah, the new employer can file a new labor cert, file a new I-140, and then you can port the priority date, but all that will take time. And usually there's, as I said, the labor cert itself will take 6 to 8 months. The priority date will not remain current for that long. It only remained current for a month, 2 months, last October. So a lot of people ask me this question, if I should go back to my old employer, file, and then go with and then change to new employer. See, that is the problem. That's what, AILA and everyone will advise you not to do, because it's not a bona fide job offer. You're going back to the old employer simply to file the green card. You already got a better opportunity and you already joined that company. So it's going to be questionable as to why you went back to the old employer, whether why you're filing through the old employer. If you go back and join them on the payroll, then it's less questionable. But if you're working for company B and company A filed your 485, then definitely it's questionable as to whether company A actually has a job offer for you since you all left them, and whether they intend to hire you after you get the green card. It is, after all, the green card, the 485 is an offer of future employment. So you can argue that, okay, we don't have to work for you now. I'll work for company B now, and I'll work for company A once I get the green card. That's fine. You can do that. But I think your green card approval will be in jeopardy because they will question the availability of the job and whether you want to join that job, whether you intend to join that job or not after you get the green card because you already left it. So something to keep in mind. If you go back to your old employer, continue with them, don't do the AC21 and don't transfer employers, then yeah, it's fine. You are sticking with them until you get the green card. Even after that, you work for them for 6 months. After you get the green card, then nobody will question. Otherwise, that question can come up at a 485 interview, or it can come up even after it gets approved, your green card gets approved at a citizenship interview. So just something to keep in mind.
Okay. So can an EB3 I-140 downgrade be denied?
Yeah, absolutely. And we kind of briefly discussed this because there's nothing in the law or regulation that precludes, first of all, the existence of two I-140s. So you can have an I-140, one under EB2 and the other under EB3. So you can have multiple, they can be in existence, multiple approved petitions on behalf of a single beneficiary, even if filed by the same employer. Same employer, you can have several I-140s. And by law, the beneficiary is entitled to capture whatever the I-140 is, capture the earliest priority date, meaning use the I-140 which has the earliest priority date when a subsequently filed petition is approved. However, in the current restrictive adjudicative environment, which means once you file with USCIS, there's no longer a guarantee that anything will get approved. You can't foreclose the possibility of a USCIS examiner inventing even a wrong reason to deny, erroneous, so denying it wrongfully, right? They might just give some reason which is not even relevant and deny the petition. And then you have to file a motion, you have to refile. It becomes very difficult, even though they are wrong and you're right. So yes, it can always get denied, even if the facts are the same. Even if the EB2 got approved 6 months ago and you're filing an EB3 based on the same facts, same tax returns, it can still get denied. So also it can get denied on legal grounds, right? Not just erroneously, but also on legal grounds. Such as if the employer cannot demonstrate an ability to pay, as I was talking about, the wage to the beneficiary, if the tax returns show losses, or if maybe USCIS revisits the issue and it did not pay attention to that issue previously when it approved the case, but now it's going into more detail and finds more holes in your application and, points out those holes. And sometimes maybe the degree was not a proper degree and they did not check and they approved it. So maybe the first time they approved it, it was an error and they correct the error, unfortunately for you, and it gets denied. Or it could be an erroneous error, or it could be something they haven't looked at, or it could be changed circumstances. So whatever it might be the reason, yes, a downgraded I-140 can be denied.
Okay. So we have a caller now. Is Praveen from Pennsylvania?
Hello.
Yeah. Hi, Praveen.
Hi, Prashanthi Garu.
Hello.
Yeah, I have this question regarding one of my friend. Actually, she's been in US and she has a family, husband and kids in India. And what do you think, if she goes to India, because it's been a very long time, she has met her family. So she wanted to check with you, but I guess she tried reaching the number. She says the number was not available, so she asked me to call. So her question is, what do you think the best idea is, if the kids are coming to US, or is she going to India for a vacation, or they had H4 stamping till June, but it's been expired. I guess they're eligible for Dropbox for the H4 stamping for their family. So what do you think, what is the best idea on this?
Yeah, that's very unfortunate. And during this COVID travel ban time, and even over the entire year, there's been so much travel restriction due to COVID, due to politics, due to whatever, it's many reasons. And a lot of families, we've noticed a lot of family separation for extended periods of time. And like you said, people have gone back to get their visa stamp, thinking that, okay, now COVID is less in the US and things have opened up, because the consulates were just starting to open up before the second wave hit India. And so a lot of people went for stamping and just got stuck there, because then COVID became more, and then travel ban, etc., etc. So in her situation, if she goes to, unless the kids are US citizen kids, are they US citizen or no? Is the caller still there or not?
Yeah, their kids are like big kids. Like one is doing his bachelor's and one has completed her, one is doing her high school. In India, what do you call the inter? And the other kid is doing his bachelor's.
So they're not US citizens. I'm asking if they're US citizens or permanent residents.
No.
The children.
They have H4 visa stamp.
Okay, they're on H4 as well. Okay. So then the problem is she cannot travel, because if she travels, then she cannot come back. Right? So pretty much I don't know what to say in that situation, because if she travels, well, one way is she travels and she works remotely for her company, if they allow her to do that, and if there's no tax issues, and then all of them come back once the travel ban is lifted, or if there is an exception that she falls under for the travel ban, then she can come back after she visits her family, and her family can come with her, provided they fall under one of the exceptions, and there are many exceptions to that travel ban. And economic hardship, something as broad as economic hardship, loss of job is one of those, or economic hardship to the employer, or if she's working in the healthcare field, that could be a hardship. So, either she can try working remotely from India for a while and then wait for the travel ban to be lifted, or try to come back using one of these, of course, after doing the proper research, using one of these exceptions. But then again, the other problem is that the consulates are not open. She might not get an appointment, an emergency appointment. So it's a difficult situation. I think if she cannot be separated from her family anymore, she should think of working, getting a situation where she can work for the next 6 months from India. And then everybody comes back on H1 and H4.
Hello.
I think we've answered that person's question.
Yes. Ms. Prashanthi. Okay, so let's go back to our questions. So if EB3 I-140 gets denied, will the applicant previous I-140 EB2 be safe?
So in general, I would say yes, because, we're filing a new application, a completely different application. But suppose the grounds for denial of the EB3 were based on issues that were relevant to the approval of the EB2 as well. Then, such as maybe the degree of the beneficiary, they don't even qualify to start off with, and they didn't notice it when they approved the previous petition, and now they noticed it and then they denied the EB3. Or if it was based on an ability to pay issue that they didn't notice earlier, and they approved it then, and now they don't approve it. There's a risk that the I-140 filed under EB2 could also get revoked once they deny the EB3, depending on the issues. Therefore, before filing, I think it's important to obviously consult the attorney, and the attorney has to do some due diligence to evaluate the totality of the beneficiary situation to decide whether it's a good thing to do a downgrade or not. So don't do anything blindly, because that, yes, it could affect your previously filed petition. It's unlikely, but it's possible. So it's important to look into those issues of qualification.
Okay. So I-485 possibility to change employer. What issues can be expected? Would change in location or job duties, salary be any issues?
Yes. So when the job, so one of the potential pitfalls of this filing 485, because it takes so many years for it to actually get approved, because we're filing based on dates for filing, and that's not the actual availability of the green card. So it just allows you to stay on, people have stayed on that status for many years. And then things obviously change. So when a non-citizen's job has changed since the filing of the labor certification, it could be a problem, right? Because the job, as you advertised it in your labor cert, no longer exists. So for example, many non-citizens have been waiting for so many years. And then because of the backlogs of this, whatever the EB2 or EB3, their labor certs could have been filed as early as 2009. This is 2021. So anywhere from 2009 to 2014. So at that time when filed, for example, if you filed as a software engineer years ago, you might have obviously the technologies keep changing every 6 months, especially if you're in the IT position. So the technologies needed at that time might be very different from the technologies needed now. And then the Labor Department also keeps changing its classification. So the code that was used for software engineer then, that was 151031, they changed that recently to 151132. Also, the wage being paid is probably higher. Over the years, everybody gets a salary increment and then you get a promotion. So, even if you're with the same employer, you qualify for a higher position, sometimes your salary is doubled. And also the title might have changed. You might not anymore be a software engineer. You might have become a vice president or director of software projects or vice president of software engineering department, or, so as a foreign national gains experience and moves up in her career, this is good news, of course, for the foreign national. It may not be great news for the employment-based petition, because the job has to still be the same or similar, and it has to still match with whatever you filed so many years ago. You said software engineer, you said C, C++, Oracle, or whatever tools you put in. That was very specific, because based on that you filed advertisements and you said based on those skill sets, I didn't get anyone else who had that exact combination of skill sets, and that's why we proceeded with this employee's application. So many are now finding that logically their job descriptions have evolved and changed since the approval of the labor certifications, and some have been promoted several times. So while 204J, which is the AC21, I was talking about the portability, allows the worker to exercise job portability, not only when you transfer to a different employer, but also with the same employer. You can file a 485J and the job may have changed. As long as it's the same or similar occupation, you still might be okay. Provided, of course, you qualify for that portability provision, which is basically, as I said, 6 months should have passed from the time your 485 was filed, and your I-140 should have been approved. But say if the job portability that is not available because your I-140 was not approved or whatever, or you're filing a new I-140 now, right, because you downgraded. A lot of people have I-140s from 2009, but they downgraded in last year in 2020. So they have a new I-140 now. But they had the same labor cert from 2009 or 2004, whatever, 2009. So the job is still very old. It's an old job. And your I-140 is not approved, so you cannot port. So this is where the problem occurs, because you cannot use AC-21 to port. The job has to be similar or same, and you don't have the flexibility of using that AC-21 because your job is not supported based on that originally filed labor cert. So I guess when these rules were first invented, they were not designed to handle cases with so much delay. Nobody envisioned that there would be a few years of delay even. And now there's a few decades of delay. So if the job has changed, drastically changed, then the employer may need to file a new labor cert. And then they can, of course, keep the priority date. But they'll have to maybe file a new labor cert, file a new I-140, and then port that, recapture that old priority date. So again, there's no yes and no answer. It depends on the situation as to when it will be a problem and when it may not be a problem. So alternatively, another alternative is the employer may still offer the position in accordance with the terms of the approved labor, meaning based on the old labor, they'll still say that, no, this is the position, even though they're using COBOL and whatever, some software which is not even used anymore. They'll still insist that this is the position, we are still using this software. But then they have to be able to justify it because the old job may have become obsolete due to advances in technology. And it would be unreasonable to require the foreign worker to regress in their job, right? Presently on a H1, they're working as a software engineer manager, and you're asking them to accept the position of a entry-level software engineer. Or maybe they're working as the labor cert was filed as a programmer, and now they're working as a manager. Is it believable to think that you're offering them salary level which was 10 years ago and that they'll be willing to take? That's a valid job offer. I don't think USCIS will believe that. There's little guidance from USCIS on this, on how to deal with career progression after labor cert has been filed. Although it has been established USCIS policy that any material changes in the terms and conditions of the labor certification would require a new labor certification or require an amended petition. It might be difficult to do that because when you file the labor cert and you go through the entire process, by then the visa number may no longer be available because it regresses every month. And it may not even get approved when you file a new labor cert. Because, for example, when the situation, whenever the US economy, there's a downturn in the US economy, they always scrutinize these labor certifications much more. And they audit them. So it's not necessary every time you file a labor cert that it should get approved. So it's possible that the labor cert might get denied. So, this is definitely a problem. But I think there has been some flexibility from the USCIS point of view, and they are, at least from what I have seen in my filings, they are, even if we give a new updated job with new skills, and even though the salary is more, as long as it is a similar job, even though they don't qualify for AC-21, they're still accepting those cases without the need to file a new labor cert. So let's hope that they continue doing that, but they can easily stop doing that. And because as per the regs, if there is a material change in the conditions of employment, a new labor cert is required. So they can easily require that a new labor cert be filed after everything has been I-140 is filed, 485 is filed, they're about to get the green card. They might just deny it and say that, we would require you to file a new labor cert. After 10 years of being on a 485. So hopefully that won't happen, but it's a possibility.
Okay. So viewers, if you have any more questions and would like to reach out to Prashanthi Garu directly, her number is 212-354-1010, extension is 107, and email address is prashanthi@reddysq.com. So, Ms. Prashanthi, what are the predictions for the July visa bulletin and what are the predictions for movement in India EB category for the rest of the year?
So we got advance notice of the July visa bulletin, and I had it with me. I would need to most probably look for it, but there's been advancement for the July visa bulletin as well. But there's also been, as I was talking about earlier when we first started on the topic, there has been a lot of prediction on the possibility of the visa numbers moving forward in the near future. And just to give you an idea, the visa limits this year will not be reached, as I said. For family-based categories, the limit will be 226,000. For employment-based, it will be 290,000, an all-time high, second highest only in recent history. China and India EB2 final action dates will continue to move forward throughout the summer as well as in October. We don't expect the final action dates to retrogress because often we see that they move back and they move forward. It's not just forward, they move back also. We don't expect any retrogression until next year. Next year there might be a retrogression once all the consulates open up and things are back where they're supposed to be, because there's a backlog of 500,000 cases right now at the consulate. So once that is cleared up, obviously there'll be more demand for the visa numbers, and then we expect some retrogression there. So family dates also will continue to advance throughout the summer. India and China will use most of these visas. We know that because they are the most backlogged. So whichever country is backlogged, they give those countries the available visa numbers. The final action dates, as I was saying, that the final action dates move back and forth based on what the demand is at the offices, with the officers. So if the USCIS is faster in processing cases, they will request for more numbers, and then more numbers will get used up, and then there'll be a backlog. As I said, retrogression will not be expected for final action dates for 2021 or 2022. And once by end of 2022, then the dates will stop moving, and most probably there will be retrogression in the second half of 2022. We're expecting very aggressive movements the rest of the time. Also, family-based category F4, we don't expect too much forward movement. So most probably EB3 will reach 2016. So that's something to look forward to. So these are some of the updates. I think we're also running out of time. So yeah, and we can talk about more updates, I guess, next time when we're, next week. But these are some of the updates.
Yes, thank you.
And we have a lot of other topics that we were not able to cover today, but I guess we can cover them next week as well.
Sure. Thank you so much. Thank you so much, Prashanthi, for clarifying all our questions. Viewers, before we wind up, if you have any questions and would like to reach out Prashanthi directly at 212-354-1010, extension is 107, and email ID is prashanthi@reddysq.com. This is Swarna signing off. You're watching Telugu Prajala Manasakshi, Sakshi TV. Namaste.
Thank you.